Okay, I think we'll go ahead and get started. We have a few more people joining in, but it's just after 11. So good morning, everyone. Thank you so much for joining us today for our Wage and Hour webinar, 5 Common Mistakes in Wage and Hour and their class action implications. For those of you who don't know us, I'm Liz Johnston. I'm an attorney in Barrels Employment and Labor Group, and I'm here presenting with Doug Currier. Doug's a partner in Barrels Employment and Labor Group. He has extensive experience in virtually all things employment, but particularly in wage and hour matters in both employment and the traditional labor context. I also have a particular interest in wage and hour issues in my practice, so we're really excited to be here today to present to you on this topic. Before we get started, we have a few housekeeping items. The webinar will be recorded, and the recording, as well as a copy of the PowerPoint, will be sent to each of you within a few days. We'll also be providing the SHRM certificates in a few days with that as well. The program has been approved for 1 credit of SHRM and 1 CLE credit for any attorneys out there in the audience as well. During the presentation, your microphones will be muted, but if you do have questions during the presentation, please feel free to send those to us through the Q&A function. If you haven't used that before, it's at the bottom of your screen, labeled Q&A. Only Doug and I will be able to see the questions that you're submitting, I believe is the setup that we have. So feel free to use that to ask for clarity on anything that we're discussing. We'll try to get to questions as they come up through the presentation. And if there's anything that we don't get to, we'll try to touch base on that at the end. So diving into today's content, we're talking about common wage and hour pitfalls with a focus of how they might play out in a class action. And I think when folks hear the term class action, there's often a common misconception that this only happens to big national, international companies, corporations, employers that are intentionally skirting rules or purposely engaging in some improper practice that leads employees to sue and begin a class action. It can never happen to us, right? We aren't big enough. Maybe your employees are very close knit. Don't think anyone would pursue that. But the reality is that there is a risk for many employers, particularly in the wage and hour context where there's real money at play. If similar issues impact enough employees, even if the issue is an oversight or wasn't purposeful on the part of the employer, a class action is something that could potentially occur. So today we're going to be talking about some of the most common mistakes that we see in the wage and hour arena, how some of those common issues play out in class actions, and most importantly, I think review some of the fundamental elements of these concepts to help you be able to cross-check your organization's practices to avoid the risk of a class action happening to you. So next slide, please.
All right, so I think this is me. Thanks, Liz, and good morning, everyone, and thank you for joining us. So we've done a lot of these seminars over the years, and some of the feedback we get is that it's good information, but sometimes it feels a little bit overwhelming, or it's a little bit discouraging because of the sort of the legal implications and all that's at stake. And so I'm going to give you a forewarning that this is going to be one of those times, I think, where you're going to walk away saying, well, all right, good information, but that scared the heck out of me. And there's no way to soft sell that. I just think that's the reality of this situation when we're talking about the potential for class actions. And the reason we decided to have the focal point of this presentation to be on class actions is because we are seeing more and more of these types of cases, and plaintiffs' attorneys are becoming more well-versed on how to pursue a class action, how to get through the certification process, the class being certified, so that they can have a collective case. Now, from the plaintiff's attorney's perspective, it is very lucrative to bring a class action because more often than not, their attorney fee agreement will provide for a significant percentage, say 40% of the of any settlement. And so if you bring a claim for an individual employee and that person's claim is worth maybe $10,000, they might get some statutory attorney's fees, but ultimately it's it's not going to be anywhere near the amount they might get in a class action. They're able to bring a class action that involves representing 500 employees and the amount at issue is $10 million, and they get 40%, then their payday for pursuing the same type of legal issues they would on behalf of an individual employee may be in the $4 million range. So there's a lot of incentive for plaintiffs' lawyers to explore the possibility of bringing class actions, and as they become more and more aware of that, they are actively trying to position cases in that context. So typically a class action happens when there is a commonality of facts that are so similar that a group of employees' claims can be tried as together as sort of one and the same. And more often than not, that happens in the wage and hour context when the employer has a single policy that is applicable to all employees. And so to give you an example, let's say that you have a quarterly production bonus and you fail to include that production bonus in the calculation of overtime compensation for employees. And just taking a step back, if you're not familiar with this, because it is a common mistake, is a lot of times employers don't realize that bonuses have to be factored back into the weekly or biweekly wages paid to employees to calculate whether or not additional overtime compensation is due. The fact that it's paid quarterly doesn't mean that it somehow does not have to be considered for purposes of determining overtime compensation. And so in that situation where a plaintiff's lawyer might say is, look, they have a policy. It is to not include production bonuses in the calculation of overtime. And that is a single policy that's applicable to all employees who are eligible for this production bonus. So we can have a class action because of the commonality of facts, is really determinative of this whole legal claim. Now, another example might be a situation where an employer has, say, 10 team leaders, and it treats those team leaders as exempt under the executive exemption, and the argument being that they don't actually qualify for that exemption. And a plaintiff's lawyer might say, I want to represent all 10 of these team leaders to bring a claim. And then the question would be, okay, are their job descriptions really the same? Are their actual job duties the same, such that there's a commonality of facts where they can be treated as, their claims can be treated as sort of one claim, one group? Or are there differences in what each of the team leaders do, so that there'd have to be a factual determination as to, whether or not this person meets the test, and this other individual, whether or not their performance of the job meets the test, and that because there are variances in how they do their job, the authority they're given, that type of thing. And so that's leads to the question of whether or not this group of employees who the plaintiff attorney tends to that wants to represent can be certified by the court as a class, and that when a claim is brought, that's the first major step in the case, is for the court to determine whether or not it's appropriate for a class action. And more often than not, what the employer will do is try to argue that there are individual circumstances such that it is not appropriate to certify the class. Sometimes you have arguments where that might work. For example, in the situation of the team leaders who are treated as exempt or non-exempt, wrongly treated as exempt, where there might be some factual differences there that would defeat class certification. But when you have a policy like the production bonus that I referenced, there it's going to be harder to say that there are individual factual circumstances that suggest that certification is not appropriate. Because in the end, the fact that you're going to have to do different calculations because people work different amounts and had different overtime, that's not going to make a difference as to whether or not the class is certified. The question is whether or not this single policy was applied to everyone on sort of an even basis. And once the court determines that's the case, it's almost certain that class certification will be approved. So let's take a look at this then from a perspective of your exposure. And we know that there are federal laws that we talk about under the Fair Labor Standards Act, but each state has its own individual laws as well. And we have clients on this call from different states, but for ease of the discussion, I'm just going to focus on some of Maine's laws right now to just emphasize that the analysis has to go beyond, what is the federal rules in place, but also you have to look at the state laws, which are often more onerous than the federal laws, Maine being a good example. So for Maine, when you have a class action, the plaintiff's attorney will be seeking treble damages for the entire class under the various wage payment statutes. And in addition, we'll be seeking attorney's fees, which becomes an issue if it's actually the case goes to trial. Because if it goes to trial, there will be an award of attorney's fees if they are successful. If it doesn't go to trial and the case settles, then the attorney's fees will be determined based on the attorney fee agreement, the 40% that I talked about before. In addition, under Maine law, if you violated a state statute relating to the payment of wages and the like, as I said, the employee would be entitled to treble damages. And unlike other states, Maine has no good faith exception. So the fact that you did your best to comply with the law, perhaps you talked to an HR consultant, or you talked to an attorney, or you researched it online and you got the wrong answer, you thought you were doing it correctly, it doesn't matter. The only question is whether or not you violated the law. And if you did, then there's treble damage and attorney's fees that the employees are entitled to receive. In addition, under the Fair Labor Standards Act, the statute of limitations is 2 years. It's a 2-year look back, unless it's a willful violation, in which case it's a 3-year look back. But in Maine, the statute of limitations is a 6-year look back. So that means that if class action is brought against you, they're going to look to see to what extent you violated the law for the past 6 years. And that will include some of your current employees, and it'll also include some of your former employees. And so when there is a class action, there will be an effort to represent both current and former employees. Now, let's talk about what this means from a practical point of view. So, because I think you just need to understand that when you're talking about a class action, that the costs can rise significantly. Let's consider the 2 examples I gave you. Let's say with respect to the production bonus that you have 100 employees who qualify for that bonus. And the amount of extra overtime that they're entitled to receive every quarter because they got this production bonus is probably a relatively small amount. For our purposes, let's just say it's $30 for each employee on average per quarter. And so for one employee, that's $120 over the course of the year, which doesn't feel as though it's that significant amount of money. But if you take that $30 per quarter per employee, and there's 100 employees, that means we're now talking about $3,000 per quarter times 4 quarters times 6 years, which then totals $72,000. Now you treble that, and now we're talking about damages of $216,000 for this, what seems like a really simple, inconsequential mistake in the scheme of things, since it's really only about $30 per employee per quarter. Then on top of that, you have to add the attorney's fees, and you have to also add legally entitled to interest, which will, given the fact that you're essentially paying interest on the amount you've owed for the past 6 years, can be actually a fairly significant amount. So, again, you can see how that starts to get to be a significant claim. But the reality is that a lot of the claims get a lot more significant than that. And let's take the 10 employees who are treated as exempt. And let's say that they, on average, work 50 hours a week. So they're entitled to 10 hours of overtime for 52 weeks for 6 years. And if you assume that their salary breaks down to an hourly rate of $30 an hour, then if you do the math, and you'll have to trust me on this, then that means that the amount of exposure is $1.4 million, plus attorney's fees and interest. Now, we've also seen cases where you have policy violations and the like, where the claim, because if you do all this math and add all the numbers together, it's even more than that. It can be in the tens of millions of dollars because of a simple mistake that is just made for multiple employees, over and over again over a 6-year period. So this is something that you need to take very, very seriously. And some of the takeaways that I would leave you with as we're about to move on to the next slide is that, first of all, you got to approach this with a healthy dose of paranoia, that you shouldn't just assume that what you're doing is correct because it's been done that way for years, or because you've heard that others do it that way. It's important, I think, to audit what you're doing and to just check in to say, is this okay? Are there any issues here? Has the law changed in any way? And to just be mindful that this is something that it's worth double checking. Second thing I would say is an important takeaway is do not ignore any employee questions or complaints about what they feel like are unfair wage practices. Because experience has told us that when they come to you and say, should I be paid for this, or should this be part of my overtime, or should I be entitled to overtime? A lot of times when they don't get the answer they want from you, they go and talk to a plaintiff's attorney. And the plaintiff's attorney will be very interested in, first of all, trying to determine whether or not there is a violation. And then second, asking the question whether or not this applies to other employees such that they can bring a class action. And then they can use that one employee as the named class plaintiff to bring a claim on behalf of all similarly situated employees. The other thing I would just suggest is you go through your termination checklist as to whether or not you can let someone go, that you, beyond just the question of are we doing this lawfully, is there a risk of discrimination claims, whatever the checklist may include, that you just ask, is there any exposure to this employee for potential wage and hour claims? Because that's when they're likely to talk to an attorney if they're unhappy about their termination. And the attorney might say, look, we don't have a claim for wrongful discharge, but I do think you have a claim for wage and hour violations. And so I would make sure you're just mindful of that. All right, next slide, please.
All right, thanks, Doug. We did have one quick question following up on a comment Doug made about the overtime payments being calculated into overtime. Should year-end bonus payments and profit sharing payments generally be considered in the calculation of overtime? Maybe, but probably not for profit sharing. Those payments, if it's a bona fide plan, can generally be excluded from the overtime rate. Discretionary bonuses can also be excluded from the overtime rate. It's the non-discretionary sort of production-based or promised bonuses that do need to be included. I don't know if you want to add anything else to that, Doug.
No, I think you're right. I do think, without actually looking at how the bonus plan is communicated to employees, it's hard to really answer that. I think just the fact that you have that question is probably worth checking with your attorney. Again, is with that sense of paranoia. Just because it's paid on an annual basis doesn't mean that it shouldn't be included. It's really a question of whether or not it's discretionary or not discretionary.
All right, so with that, we'll jump into mistake number one. And I'm glad Doug gave that warning about this being a heavy sort of substantive day in some respects. This slide is no exception. So mistake number one, not paying all working time. I'm sure all of you know the general rule is that all time employees spend working or on the job needs to be compensated for. And this includes all time that an employee is suffered or permitted to work, is the sort of legalese definition there. In other words, all time employees are required or allowed to be performing job-related duties. So oftentimes that's clear, depending on your industry, it's when employees are at their desk, they're working on a project, when they're on the floor, on the line, building widgets, we know that time's compensable. But where we see mistakes is not compensating for time that's not directly work, but the time is in fact being spent on things that are sufficiently tied to an employee's job duties, such that it constitutes work time under state and federal wage payment laws. So there's a variety of types of time that might be compensable, and we'll talk about a couple of those here. But for some of these, there's not necessarily in all cases, a state law or a state regulation that specifically talks about these categories of time. Often we need to look both at federal law and state law for guidance on what's going to be compensable time, what rules, regulations are in place governing that time to determine whether it's compensable. Most employers are going to be covered both by state law and the Fair Labor Standards Act. And Maine courts do actually look to federal regulations and federal laws to help fill in any gaps that might be existing in state law if there's not already express guidance on it. So it's important to be making sure you're being compliant with both state and federal law that might apply to these categories. Also, these issues are particularly relevant to your non-exempt employees. So we know that exempt employees are paid a salary that covers all of their hours worked, aren't necessarily required to be recording all their time. But for employees that are paid hourly, are required for overtime, these categories are particularly important to pay attention to. So one of these types of times that might be compensable, rest breaks and meal breaks. Short rest breaks, typically those 5 to 20-minute breaks, are generally considered compensable work time under federal guidance because the employee is not sufficiently relieved from duty to go use that time on their own for their own benefit. Feels a little counterintuitive, especially these days when you can virtually do anything from your phone. So they could, really be using that time to book a vacation or FaceTime a friend, use that for their own benefit. But federal guidance is fairly clear that any short break like that does need to be paid for and counted as work hours to get to that overtime calculation as well. Employees shouldn't be clocking out for those breaks. Employers shouldn't be making deductions for those breaks. And that also applies to smaller breaks throughout the day, like grabbing coffee, going to the bathroom. Those do need to be paid. So meal breaks are a different story. Meal breaks aren't necessarily compensable if they are, typically we say 30 minutes or longer. Those can generally be unpaid so long as the employee is completely relieved from duty during that time. But if an employee is doing any work, if they're checking emails, if they're running a work errand on their lunch break, if they are doing anything that's work related, they're not completely off duty. And that would be both a potential violation of state law regarding requirements to provide meal breaks to employees, but also the principle that all work time needs to be compensated for. We do see some employers doing automatic deductions for breaks, particularly lunch breaks, say, automatically subtracting 30 minutes from the time worked to account for the lunch break that employees are supposed to take. But these do have potential risks to them because you can have situations where employees are called back to step in and help somewhere while they're on their break. Maybe they just work for a few minutes. Maybe they end up working through their whole lunch. Maybe they forget to email their supervisor to let them know that they actually worked through that break. Some employees might have a habit of just getting some extra work done while they're eating their salad or, at their desk. But if an employer is automatically deducting that time when it should be paid, it's creating a recurring issue that is going to add up day after day, as Doug was talking about for groups of people. And over the course of years, when it applies to a big group, that's going to create a practice that's creating liability based on those automatic deductions for time that should be paid. Some other time to think about in terms of whether it's compensable is travel time. Typically home to work travel is not going to be compensable, but it's that intraday travel that particularly is an issue in the class action world. If employees are traveling from different job sites to other job sites during the workday, going from client to client, that time between those work sites spent traveling between those clients is potentially going to be work time that they need to be paid for. And we have seen that play out in class actions where we need to go back and piece together those little breaks of time to make sure that they're being paid. And oftentimes it adds up to create overtime liability as well. So not only from a financial aspect can it be very significant if there was to be an action, but it's a very difficult in a practical sense to try to piece all that together years down the line if you're facing an action for that. Pre-shift and post-shift activities and duties. These are things that may not seem directly like work, but time spent on things like unlocking doors, turning on equipment, cleaning, taking the trash out at the end of the day, all of those activities that are serving the employer need to be compensated. Even something like walking from one area to another before a shift might need to be paid. There's a recent court action recently where a court certified a class of 6,000 workers. One of the allegations is that the employees had to walk a 7-minute walk from the door to get to the time clock. And they're alleging that that time should be paid. And if that time had been paid, it would have created overtime for these employees as well. So that's, something we'll be watching to see how it plays out, but shows sort of again, those small increments of time adding up to liability for a big group. On-call or waiting time, if an employee is required to be on site or even elsewhere waiting for work, or just being on call in case something comes up, that might also be compensable depending on the restrictions that the employee has while they're engaged in that waiting time. Are they allowed to travel? Are they allowed to go out of town? Are they allowed to leave the work site? So all factors in determining of whether they need to be paid for that time spent waiting, even though they're not actually working. And trainings and meetings is also a significant one. This relates to not necessarily just like job related training or specific, meetings that are part of the employee's work, but think about company meetings, company events, even if they're social events. If employees are required to be there, or if it's related to their work, or if it's during their workday, it's likely that that time spent on those activities is going to need to be paid. And this one can be particularly sticky in terms of figuring out whether a training or a meeting or an event is truly voluntary. Again, because if it's not, it's looking more like work time. But something can be non-voluntary, even if it's not absolutely mandatory. If not attending a meeting or not attending an event is going to look bad or have some sort of, impact on the employee's perception in the company or their performance, if it would be brought up in a review, it's possible that's not going to be a voluntary event. Again, one of the factors you need to think about in terms of whether it's going to be compensable. Off the clock work is another big area to pay attention to, particularly with remote work becoming more frequent. It's not necessarily just work that the employer is assigning or the employer is consenting to. So if an employer has a policy that says, hey, you're not supposed to work after 5 p.m. when the office closes, but employees are still doing work after hours, that's compensable work time. And we see more and more non-exempt employees that have email on their phones, taking company laptops home, checking and responding to emails after the work day, working on things at home. Maybe they're not telling an employer. But even if an employer, again, has a policy saying don't work after hours, if it's being done, it needs to be paid. So it's important to make sure that employees are abiding by those policies that you have in place. So if you're getting emails at 8 p.m. and never seeing any time recorded for that period, that's something you need to follow up on, because again, if you know it's happening, and even if you don't, that's compensable work time. And if it's not paid, it might be subject to an action later. And with that, I think next slide.
So, following up on what Liz was just talking about, sort of working off the clock, one of the things that we see that is very problematic and all too often happens is employer not keeping accurate records. And it is the employer's legal obligation under state and federal law to keep accurate time records. And if you have a situation where the integrity of your time recording system is questioned, and the employee maintains that they worked more time than the records suggest, from the Department of Labor's perspective and from the court's perspective, the benefit of the doubt is going to go to the employee, because it is your obligation to keep accurate records. And if you don't do that, then they're just going to take the employee's word for it. And I had a situation where, to drive home this point, where at a nursing home, and the shift started at 7 in the morning, a lot of the staff would come in early, and they would just punch in. They'd go to the employee break area, and they would sit around for the 15, 20 minutes, half an hour, however long it was, until 7 o'clock hit. And they would just, catch up with each other and enjoy the time together. And then when it turned 7 o'clock, they'd go to work. And the employer knew this, and so just paid them from 7 o'clock on. Problem is, when the Department of Labor came in to do the audit, the time records show that they were starting at 6:45, 6:35, or 6:30. And the employer explained, well, they punch in, but we know that they don't actually start until 7 o'clock. And we actually had the Department of Labor investigator watch the employees come in, punch in, go to the break room, sit around, and at 7 o'clock they got up and went to work. The Department of Labor said, we don't really care. You have records that suggest that they started working earlier than 7 o'clock, and that's what your records say, and you're going to have to pay them based on those records. And that then was every employee for years, and all resulted in overtime compensation. Now, we negotiated a deal that resulted in a significantly smaller payment, but you just don't want to find yourself in that type of situation. If you do have records that are inaccurate, the employee forgot to punch in or punched in early or whatever the case may be, one problem that we've seen is where employers just make the change themselves without getting any sort of acknowledgement from the employee. And then when the employee later makes a claim, asserts that change was not appropriate, that they worked that extra time or entitled to that extra money, and the employer is trying to say, no, this was an appropriate change because you actually didn't start when you claimed you started, or whatever the case may be. Again, you find the benefit of the doubt goes to the employee. And so when you have a situation where you're correcting mistakes, it's really important that you get the employee to acknowledge the change in the time record so that there's no fighting about it later on. And you just have to realize the dynamics of a lawsuit are such that a plaintiff's attorney just needs to win on something. If the employee claims that they're entitled to $5,000 in overtime, and you're able to show that a lot of that is not accurate, that the employee didn't work that much extra hours, it doesn't really help you that much in the scheme of things if you can't prove completely and totally that they're not entitled to additional dollars. Because if instead of getting $5,000, they only get $1,000, their attorney still gets the attorney's fees associated with that claim. And if you fight about it, that means there's more attorney time spent, which means that the employee may only get $1,000, but the attorney's fees at that point may be $25,000. And so because of that sort of difficult dynamic, the best thing you can do is making sure your records are absolutely accurate. Liz talked a little bit about automatic deductions. This is an area where we see a lot of problems. Make sure you have clear policies in place about how those deductions work, and that it's important that the employee notify their manager that if there is an exception, if, for example, if there's an automatic deduction for the lunch period, but the employee has to work through the lunch period, that it's very clear in writing that the employees have to tell their manager that that's the case. And you should make sure that you have some examples where employees have in fact done that, and you have made the makeup payment because the person worked more than they were supposed to because they had to work through their lunch. Our experience in litigation is that it is hard to say that the automatic deduction policy works and should be viewed as valid if you can't show that there have been times where exceptions have been made and the employee's been paid. And it always happens. And so if the facts are that you never have an example of an employee working through lunch and being paid, it's going to undermine the credibility of your claim, because no one's going to believe it. It just never, ever happens. It is also something that you should do in an audit, is to really check to make sure that this is happening. Check in with employees to make sure they're doing it, check in with supervisors to make sure they're confident that employees are letting them know if they're working through lunch, and that exceptions are being made when necessary. Also, when you have an employee sign a release agreement, understand that without court approval, employees cannot waive their rights and claims under the Fair Labor Standards Act. So it's very important that you include in the release language a representation by the employee that they have been paid all of the time for which they've worked and received all the overtime compensation to which they're entitled, because that's going to be your best shot at actually preventing future claims in that regard. In the area of vacation, oftentimes we see problems where employers don't have accurate records of vacation taken. I would emphasize that it's important, if you don't already have it, to make sure you have in place limitations on how much vacation can carry over from year to year. So that way you're not caught by surprise by someone claiming that they're entitled to a ridiculous amount of unused vacation at the time of the termination of their employment. With the carryover limitations, at least it's capped. With comp time, remember, I know I'm stating the obvious for many of you, but it's amazing how often employers miss this, that if you have a comp time policy, the comp time needs to be used during the same pay period. You cannot have a situation where an employee works 5 hours of extra 5 hours in week 1, and basically you say, okay, in week 8, I'll give you 5 hours off. That doesn't do it. It has to be within the same pay period. With respect to bonus and commissions, if there's any dispute as to what's owed, remember, it's likely the employee is going to be given the benefit of the doubt on their claim, and it's not an even playing field. If they sue you and you win, that means you have to pay our attorney's fees. If they sue you and they win, then you have to pay our attorney's fees, you have to pay their attorney's fees, and you have to pay them treble damages. So that means it's really important when you have bonus and commission plans to be super clear on how the bonuses and commissions are calculated, very clear on how they're paid out, especially upon termination of employment, and understand that the anatomy of dispute is going to be that if someone makes a claim for unpaid bonuses or commissions, the first thing that the court's going to look at is there a written agreement that spells out what is the entitlement? And if not, then they're going to look to see whether or not there's a written policy that spells out the entitlement. And if not, then there's going to be a question as to whether or not there's a verbal understanding and evidence of a consistent past practice. The best chance you have of winning is having the written agreement. The second best chance you have of winning is if you have a clear written policy. The third best chance of winning is going to be, and frankly, that's when it gets actually really a lot harder to win, is if you only have supposedly a verbal understanding or you're relying on past practice. Next slide, please. The other thing that we wanted to highlight, because this often can be the subject of a class action lawsuit, is an employer's obligation to timely pay wages. There is a law in Maine that talks about, and it's spelled right here, I won't read it out for you, that talks about the requirement in terms of paying wages. A lot of employers are like, well, really, what's the big deal if we pay late? If the employee is owed, $500 and, we pay it 2 weeks late, well, they've got their $500. I mean, it would be ridiculous to have them sue. Understand, though, literal reading of this law in Maine, and plaintiffs' lawyers are focused on this, is that if you pay it late, if you violate this law, you owe the treble damages and attorney's fees. Now, if you've paid the overtime, well, that's 1/3 of what's owed, or whatever the amount, the $500. That means that they would argue that they're still entitled to an additional $1,000. And again, if it's a situation where all employees are paid late, then you may face a class action where they're all saying that even though they were paid, they're entitled to additional monies, the penalty damages associated with the late payment. The other thing to emphasize is that a lot of this turns on when the wages are earned by the employee. And you see it there in the language. And so as you put together your commission and bonus plans and the like, you really want to think carefully about how you articulate when the money is earned, because you have some control over that. So for example, a bonus may be earned at the end of the year, or a commission may be earned instead of when the sale is made, when the money is collected. So anyways, you just need to make sure that how you articulate in your policy or your agreement bonuses and commissions being earned is very, very clear. All right, next slide, and back to you, Liz.
All right, so next we'll talk about mistake for making improper pay deductions. So Maine law dictates specific reasons in which an employer can withhold money from an employee. In other words, take deductions from their paychecks. And this is an area where I've, especially lately, seen some mistakes that we thought we'd flag today. There are only a few reasons that employers can make deductions legally under Maine law. One of those is for payments of loans, debts, or advances. This would include a traditional monetary loan, a pay advance. It could also include a PTO advance, payment for merchandise purchased from the employer, benefits and insurance. You think sick, accident benefits, life insurance, health insurance, things like that, so long as the employee agrees to it. Court-ordered garnishments, those are also allowed. But you'll notice there are a lot of things that are not on this list, but are on the impermissible deduction list. And I think some of these are particularly surprising to employers, particularly related to cash shortages, inventory shortages. Employees can't have pay deductions for those items. Damages to the employer's property. That's property in any form, whether it's physical or more tangible property. I do a lot of reviewing of handbooks, and I've seen a number of times where employers have provisions that say, hey, if you break your key cards or if you damage a laptop, we're going to deduct that from your pay. Not allowed under Maine law. It's specifically carved out as something employers can't make deductions for. It's not to say that an employee can't be held accountable for that in a disciplinary context or in some other way, but a pay deduction is not the way to do it. Uniforms, if the uniforms have employer logos on them and the employees are required to wear them, they cannot be the basis for a pay deduction. Again, even if the employee agrees to it. Doug talked about employees not being able to waive their rights under wage payment laws. Same principle applies here. A couple other ones to flag: PPE, tools that are required to be, needed for the employee's performance of the job. Those can't be the subject of pay deductions. So again, it's not necessarily the isolated instances that are going to cause issues when we're thinking about a class action, but it's those repeated deductions, those monthly uniform deductions, or more recurring practices that you're applying on a widespread basis that would potentially be issues for class actions going forward. I've also included here certain deductions from employees or exempt employees' pay. And this, I'm referring to a little bit different of a deduction here. These are deductions that we see employers make for exempt employees missing a day of work or taking a partial day during the week and reducing pay accordingly. Generally speaking, there are very limited circumstances when an employee can have that salary reduced for non-work during the week. Generally, if an exempt employee does any work during a workday, they are entitled to pay for that full day. Deductions due to taking half of a day as a personal day, if they don't have PTO, not permitted. Generally, only a partial day can be deducted if it's for a major safety violation or FMLA time or something like that. Pay also can't be reduced due to office closures or having a lack of work for exempt employees. That salary requirement for exempt employees is a really key part in making sure that they're properly classified. So the risk here is that if employers are making improper deductions from exempt employee pay, that they risk losing that classification, which would put them on the hook for potential overtime and minimum wage law violations, potentially timely payment violations. if they lose that status. And Doug's going to talk a little bit more about misclassification in our next slide.
So the Department of Labor has these fact sheets on a lot of different areas of within their jurisdiction, but they have some that relate to all the exempt categories: the administrative, executive, professional, computer employee, and outside sales. One of the things I would encourage you to do is to go online and look at those fact sheets and just read them and see if in reading them that triggers anything in your thoughts about what you're doing and if there's a way you should be doing it differently. There are a lot of traps for the unwary. There's a lot of litigation that relates to classification of employees. We could do a 2-hour segment on this topic alone. And so I'm just going to sort of highlight some of the areas for you to think about, and you can decide whether or not you want to dig in deeper. The first is there can be confusion about salary basis. And one question that was raised is talking about, non-exempt employees who are paid on a salary basis. And it needs to be said that paying someone on a salary basis does not make them exempt. You can't be exempt unless you're paid on a salary basis, with a few exceptions where fee basis is allowed. But no one should be thinking because we pay them a salary, we don't have to pay them overtime. That's just one part of the equation. And if you pay someone on a salary basis, you need to think about how you're calculating their overtime, because there's different ways you can do it. So, there's the fluctuating work week method versus sort of the traditional, well, we assume the salary is covering 40 hours, so we divide the salary by 40, and that's their regular rate of pay, and therefore we then multiply that times time and a half for any hour worked over 40. Liz has already talked about this idea of if they work any part of the day, they're entitled to their full salary, and talked about improper deductions. Understand that you can put a policy in place that allows you to correct mistakes. It's called the safe harbor policy, that if you don't already have it, you should have it in place. And if you go on to these fact sheets, there's examples of how that policy should read. And that's, I think most employers should have that. And again, it's good to be able to have evidence that there were times when issues have been pointed out to your attention and you made the correction, so that you can show that it's a real policy that is taken seriously by the company. Second area relates to that I want to talk about is this concept of primary duty. A lot of times employers think in terms of, well, the employee meets the various elements of the test, but doesn't really stop to ask the question of, is that the employee's primary duty? And primary duty is in each of the tests. And primary duty can be easily thought of as circumstance where someone is spending more than half their time performing exempt type duties. But it also can be applicable where the reason the job exists primarily is because of the exempt aspect of the job. But that's trickier when you don't have, you can't meet the 50% threshold. But you should be thinking long and hard about whether or not those that are on the cusp of whether they're properly classified as exempt can show that their primary duty is exempt duties. For the executive exemption, understand it means more than just supervising employees. You have the primary duty concept. You got to be in charge of a division or a department. You have to have a certain amount of supervisory authority and the like. And so if it doesn't fall in the quite obvious rule, you should, again, and then you keep hearing this theme of conduct an audit to really take a look at it. I also think that you should look at the professional exemption and understand the difference between, the academic professional and the creative professional. With respect to the administrative exemption, it is not a catch-all. It is supposed to be narrowly interpreted. And so you really need to take a hard look at whether or not anyone you classified it as being administratively exempt that you could show that their primary duty is performing responsibilities that really require independent discretion and judgment on matters of significance. And that is a much higher test than most people think. With respect to the computer employee exemption, you need to know that a lot of employers just start pushing everyone into the exempt category. And when you read the actual test and the description of it, and again, the fact sheet will spell it out for you, you will see that it's actually a higher standard than most employers think. And that just because someone's in IT doesn't mean that they qualify for this exemption. And then finally, if you're relying on the outside sales, you need to make sure that they're really involved in outside sales. And again, I think the fact sheet is very helpful in that regard in spelling out what the test is and how that should work. All right. So I think I was just looking at some of the questions as we go on to the next slide. Liz, do you want to answer the two questions that have come in?
Yeah, so we've had a couple questions about charging employees for like a lost badge or a lost key, and regarding deductions for uniforms when an employee wants to buy more, maybe than what's allotted. Here, I think the key distinction is between a deduction and a charge. So I think charging for a lost access or for like a lost key card or something like that, that's not necessarily a paycheck deduction. A paycheck deduction would be automatically taking it out of their pay, perhaps with or without consent. But you could I think you could require them to compensate for the lost property.
I want
Whether
to
you,
jump in on that, though. You
yeah,
need to check. There is a provision in Maine about unfair agreements. And so you'd have to look at that as to whether or not it might be viewed as an unfair agreement to make someone, and again, this is what Liz was alluding to, you're not making them pay back money, but you just have to be careful that, for example, if someone does damage at work, you're not allowed to make them pay for that damage. You can fire them for doing it, but you're not supposed to make them pay for it. So I get a little bit worried about making someone pay for a lost access badge.
yeah, I think dealing with it in the disciplinary sense is more appropriate, where if it keeps happening, maybe it's warnings or, further disciplinary action that needs to be taken in that respect rather than financially, just because, again, there is so much risk with what can happen when you're withholding comp for any reason. With the uniforms, my recommendation would be to have employees purchase those things rather than make deductions. Doug, I'm not sure if you have a different opinion on that, but rather than taking deductions, even if they're agreeing to it, I think allowing them to buy them would be a safer route to avoid an improper deduction claim.
Yeah, I mean, I think you can, if they want to do a deduction, I think you can do it. Your point's well taken in the sense that it starts to merge the two. But from a practical point of view, I think a lot of employers do it that way. And it's as long as you can legitimately have them pay for their uniforms, you got to make sure it doesn't start to eat into their wages such that they make less than minimum wage. If it's something the employee signs off on in writing, I mean, it's not as clean as having them just write a check for it, but I think you could do it.
Yeah, and I think from a practical sense, the risk of a claim arising from that, because it is a one-time thing the employee is requesting or agreeing to, especially in writing, the risk is probably pretty low there. And with that in writing, we talked about deductions for loans or for PTO advances, things like that. And it's a common provision that we see, hey, if we advance you PTO, we're going to take it out of your paycheck. Maybe that's in your handbook or written somewhere. Definitely encourage, for any substantial loan or advance or PTO advance, encourage getting it in writing that employees will be subject to a deduction for that, so that it's not a really unpleasant surprise when their final paycheck is reduced by that amount, or they see those figures start coming out of their paycheck and they say, hey, I didn't agree to that. So with that, we'll jump into a couple other areas that we wanted to talk about today. One, area that we might see more and more issues coming up with is earned paid leave, and whether, class actions, not necessarily class action, but DOL actions arising out of enforcing it. One common issue that I see when I do PTO policies and review those policies is when employers have more generous policies providing PTO than is required by state law and overlooking complying with the state law requirements. So Maine's PTO law, called the Earned Paid Leave Law, requires that employers with 11 or more employees provide 40 hours of paid time off, and it needs to hit certain requirements. One of those is that if it's accrued, there needs to be carryover of up to 40 hours at the end of the year. And it also you need to have a written policy of whether it's paid out on termination. And I see employer policies, that offer maybe 50, 60, 80 hours of PTO. Employers think, hey, I'm well in compliance, and I don't, need to worry about earned paid leave because my policy is more generous. But if your employees are accruing that and you're not complying with the carryover requirements that EPL requires, there may still be a basis for penalties associated with your policy if at least 40 hours of your PTO isn't compliant. Violation of Maine's vacation payout requirement is another big one I think we might see more of later. This just went into effect in January 2023, but it requires payout of vacation time on termination for employers with 11 or more employees. And vacation time is viewed as akin to wages under Maine law. So if you're not meeting the requirement of paying out your vacation, then it's a potential wage and hour violation that, again, if you have a practice, could add up over the next couple of years over the groups of your employees that are both current and departing. Paying an improper overtime rate, we've talked a little bit about that already, but making sure that you're including all compensation that needs to be included in calculating the overtime rate and backtracking that as necessary. And lastly, our misclassification of independent contractors. Not technically employees, but as with exempt employees, if your contractors are misclassified, you could be on the hook for unpaid overtime, potential minimum wage violations, if a Department of Labor or court was to determine that they were wrongly classified as contractors. And it's getting harder and harder under state law and federal law to meet the threshold of an individual having enough autonomy, skill level, doing the right work, having enough investment in the work to actually be considered a proper independent contractors. And especially where you might have a group of contractors that do work for you, that could be a class action risk as well. Next slide.
So thank you all for joining us for this presentation. I know there's been a lot of information, and you will get copies of the slides. And if there are follow-up questions that you have, feel free to reach out to me or Liz if you need clarification of anything that we've shared. Basically, the takeaways, and we've really all covered them all, but in terms of avoiding class action risk, I think you need to review your wage and hour policies for compliance with state and federal law. We've talked about that, having that sense of paranoia. Don't just assume because you've been doing it for an extended period of time that it must be okay. Make sure you review your record keeping policies and procedures. We've talked about the importance of that. Making sure your managers, supervisors, and payroll folks really understand what their role is and that they are enforcing the policies as they're supposed to be doing. I can't emphasize enough how often the problem is a manager or supervisor who turns a blind eye. For example, if someone working off the clock just because they feel like, well, I'm not asking them to do that, and the work's getting done, and so no harm, no foul, when in reality it can really come back later to bite you. Really making sure that you're monitoring the employees for their compliance with the wage and hour policies. Are they reporting things when they, for example, miss a break or have their lunch break interrupted, things like that? And stating the obvious about staying up to date with the changes to the law. But at the end, it's putting something in your calendar that reminds you that every year you want to check in to see if there's been changes to the law, to revisit your policies, reread them again, and to do your internal audit so that you can catch a mistake hopefully early and before some plaintiff's attorney does. So with that, our next slide, I think, says questions, but we've used up all our time. And we've tried to take questions as they've come along. But again, do reach out if you have any questions or need clarification about anything that we've shared. And otherwise, thank you for attending, and we wish you all a good day.